Your Honor, may it please the Court, Attorney Charles Olminski on behalf of Richard Hahn. Your Honor, we filed this appeal because we believe that the videotape showed evidence contrary to what the trial court found on our motion to suppress. I don't think there's any question that this court has. I also apologize, I'll be reserving 5 minutes for the rebuttal. I don't think there's any question that this court certainly has jurisdiction to take a look at this. We did not request oral arguments on this matter. I say that only to say that on behalf of the defendant, I believe that the video speaks for itself. And I believe that the testimony offered by Officer Rafferty supports that video, and that everything that he saw as a violation was contained on that video, and no said violations occurred on that video. Thank you.
Good morning, Your Honors. Brian Bremer for the State of Ohio. I do think this is a pretty straightforward appeal in many ways.
Do you concede that if we look at the video, it will be dispositive?
Well, I believe that the video is, I do believe the video speaks for itself. I will say that the officer testified at trial, though, that he observed violations prior to the video starting. The portion of the suppression hearing that counsel is referring to, it was a response from the officer to a question on cross, where the officer said that it was responding to a question about whether or not the video contained all of the violations. And this has been a back and forth discussion between counsel and the officer on a couple of different occasions, and the officer's response ended up being, what is on the video is what I saw as well. Yes. The officer is pretty clear about the fact that the video is what he saw, but he also saw violations that happened prior to the video beginning.
Does the officer have to turn the video on?
It comes on, I don't know if it's in this record, but generally speaking, they come on after a minute. They go back a minute, basically, after the lights come on. So like when you turn on the lights, the camera like starts saving the previous minute of driving, and then it's saving forward.
So he had to have seen things at least a minute earlier. I mean,
Right.
Yeah.
And it's not clear, the facts of this case are the officer saw the defendant leave a parking lot of a bar at close to 1 a.m. and he started following him. And in the suppression hearing, he doesn't know how long he followed him before the video starts. He does, however, testify about, there's a point in the video where the defendant stops at a green light, basically, for about 4 or 5 seconds. And he sits there with the lights green. And the officer described that as what road that is, and also said that is about 45 seconds to a minute from the bar. And that incident occurs 25 seconds into the video. So going back on that, it's 20 to 35 seconds prior to the video starting that he's been following the defendant, based on the testimony that was at the suppression hearing. And I would say that his testimony alone would be good enough to say that the court's findings of fact were accurate, because he said he saw violations that weren't on the video. The court believed him, and that would be enough to support those findings of fact. I would also say that.
Did he actually say he saw violations that weren't on the video, or did he say what you told us, what I saw was on the video as well? I mean, did he actually make that affirmative statement?
He said that he saw multiple marked lane violations, and I'm looking up the direct quote in my brief. I believe that it's
Well,
yeah, I do believe he said that, but I need,
well, was he elaborative when he said about where those marked lane violations occurred, so that you could tell if that particular violation was occurring during that segment of tape or before?
they go through a little bit on the video during the hearing. He does say that there's moments that happen prior to the video starting. Like that does come out on, I think, redirect in this case. But the video also, I would say, it speaks for itself, but I also think that it does not contradict the officer's testimony. It shows him the defendant drifting onto the double yellow line at the very least and possibly crossing over, but since the dash cam is not, you can't tell if the wheels go all the way over onto the left of center or not. But I think at the very least it shows, it doesn't contradict it, where it doesn't, the video doesn't show him maintaining his lane perfectly, it doesn't show anything like that. He is drifting, he is hitting the line, which leads me to actually my reason I requested oral argument is that even assuming all these different, you were to decide that the officer's testimony about previous violations is not credible, even if you were to decide that the video contradicts the officer in some way, I believe that there is still, the court's finding about there being a marked lane violation is still justified. Because driving on a line is not maintaining your lane. And this is something that the courts have taken Mays, the facts of Mays in which the driver did drive over the line. They've taken that to say, well, that's the only way to get a marked lanes violation. Which isn't true, because if that were true, then that means that the line separating the lanes is actually part of both lanes. And therefore, two cars could drive in that lane, which would be an accident. Like they'd be able to drive on the line and crash into each other, and neither person would be at fault if the line is part of the lane. And that's something that the courts have not been really analyzing. Whenever they talk about these marked lane violations, they have not been thinking about the absurd result that is coming out of this when you say driving on the line is still being maintaining your lane. And the reality is, I would say the legislature is it's pretty clear to me that the legislature would have intended this to be more like a football or a basketball rule where you step on the line, you go out of bounds. Like it's not baseball, it's not soccer where you just drive on the line.
The foul's not fair anymore.
Yeah, basically, and that's the reason I wanted to at least articulate that. If you had any questions about that issue, because that's the issue that I think, even assuming the others, I believe that the officer's testimony is enough. I believe the video doesn't contradict the testimony, and I believe that there's other reasons to initiate the stop on top of everything else. Because he stops at a green light, he drives, he does weave a little bit, and he was seen coming out of the bar at 1 a.m., like a parking lot of the bar at 1 a.m., so under those facts, you have reasonable suspicion of drunk driving. But on top of that, driving on the line would be a reason to stop him.
Well, I might disagree with you on the last statement, just because you leave at 1 a.m. doesn't mean you necessarily are drunk.
No, it doesn't, but goes to the idea that it's a totality of the
It may
circumstances.
be a reasonable cause or something else, but not for the fact that he was to be brave.
Well, no, it's reasonable and reasonable suspicion to stop him. Like, in light of everything else that's happening, it's totality of circumstances, where it's not, leaving the bar at 1 a.m.,
You might be a teetotaler with all of your buddies, leaving the bar at 1 a.m.
Absolutely. But you also probably wouldn't be weaving onto the double yellow line, and you also probably wouldn't sit at a green light for 4 to 5 seconds, which it starts to add up a little bit when you watch the video that the officer, even assuming there wasn't a direct marked lane violation, there was some concern there that he would have reasonable suspicion to stop him, which is the second assignment of error that appellant raises, but it never gets articulated exactly why he doesn't feel reasonable suspicion existed in this case. And so for that reason, the second assignment of error should be overruled as a matter of course, because the argument is not being articulated.
I mean, I think that from the appellant's brief, I gathered that the whole argument about being on the line is not dispositive because the court specifically found credible the testimony of the officer wherein he said he traveled outside his travel multiple times. So I guess the implication of that is he went over the line based on that testimony.
I'd say, but the lane I would say is the lane the space between the lines, not the space and the line. And that's what I'm saying if we consider the line to be part of the lane, that means two lanes overlap, and then two people could be in their lane and crash into each other.
And no one's at fault.
And no one would be at fault, right, under that, which is why that's an absurd result that I don't think the legislature intended. And the courts that have been doing that have not been thinking about that aspect of the analysis. They just say that Mays was about driving over the line is what we're going to use, even though that's the facts of Mays. Mays did not say, well, driving on the line will be fine, driving over the line is not. Mays didn't have that question before because the person drove over the line. So under the facts here, I think that, again, the officer testified he's on the outside of his lane. And I think in the officer, I described him as going left of center. And on the facts of that, I think that's enough to affirm the trial court's factual findings. But I also don't think the video contradicts what the officer said. And on top of that, driving on the line alone would be outside the failure to maintain your lane, which would also support what the court found. So, if there's no further questions, we would ask you to overrule the assignments of error and affirm the judgment of the trial court. Thank you.
Thank you, Your Honor. A couple of things. The state is referring to drifting over the line and making a big deal about that. The court in Markham wrote, and I included this in my brief on page 6, drifting followed by a brief drive-in on a yellow line or yellow edge line constituted inconsequential movement within a lane does not give rise to articulable suspicion to make an investigatory stop. The state is also arguing that the defendant left at 1 o'clock, as this court wisely pointed out. That is not indicative of necessarily drunk driving. It's more indicative of profiling, which, as this court is well aware, is not legal and not a reason to pull over a defendant. When you look at the totality of the circumstances, the officer's testimony in the transcript, page 7, paragraph 9, the officer testifies that the defendant traveled outside his marked lane of travel. When we look at that, and we look at the case law that's presented, especially in Markham and more recently in Cleveland versus, I'm going to kill the last name, Shevchenko, the 8th District, just recently decided when the officer's testimony is contradicted by the video, the court is allowed to then look at the officer's testimony as unreliable. And I think that that's what we have in this case. The officer wants to testify, as state is presuming and arguing, that he witnessed violations prior to the video going on. But yet he also says that the video contains evidence of the defendant driving outside the marked lanes. That's why I feel that the video is dispositive and that this court should overrule the trial court's decision. Thank you.
Thank you.
Thanks.
I'm going to take the matter under advisement and say we're happy to continue when it's issued.
Thank you very much.